So, friends, it was just yesterday that we were here talking about how it looked like the Trump administration was playing games with the Constitution, playing fast and loose with the due process rights of notice and opportunity to be heard that the Venezuelan migrants had under the Constitution before the Trump administration tried to deport them, stuff them onto planes and send them to a prison in El Salvador. And we reached that conclusion that the Trump administration was playing games with the Constitution, in part based on the reporting that there were inmates at a detention center in Texas, Venezuelan migrants pending deportation, that were marched onto buses and driven out to the Abilene airport while litigation was raging on Friday night into Saturday morning about the unconstitutionality of what the Trump administration was trying to do. And we learned those buses rolled right past the Abilene airport exit, turned around, and came all the way back to the detention facility, and they put those Venezuelan immigrants back into their cells at the Bluebonnet detention facility. And it certainly smelled like the Trump administration was playing games, and they felt like maybe they were about to be caught red-handed, not giving these immigrants their due process rights of adequate notice and ample opportunity to be heard in court to make their case as to why they should not be deported. Well, now, friends, there have been some developments in a federal case out in Colorado on this precise issue. And there were actually a couple of rolling news reports that came out about what that federal judge in Colorado suspected and then what she ruled. So let's start with the first of the two articles, this from Reuters. Headline: Judge skeptical Trump's Venezuelan deportation notices comply with Supreme Court ruling. A U.S. judge expressed skepticism on Monday that the notice the Trump administration pledged to give Venezuelan migrants before deporting them under a wartime law complied with the U.S. Supreme Court's ruling that they be given a chance to challenge their removals in court. U.S. District Judge Charlotte Sweeney said during a court hearing in Denver that notices of looming deportations given to Venezuelan migrants held at the Bluebonnet detention facility in Texas made no mention of habeas corpus, which refers to the right of detainees to challenge the legality of their detention. This quote from the judge, quote, "You're acting as if these individuals, many of whom don't speak the language, would know there's something called habeas relief," said Judge Sweeney, an appointee of former Democratic President Joe Biden. Quote, "I'm looking at the notice now. It gives no indication of any right to seek any type of relief." And friends, believe it or not, here is what Donald Trump's DOJ lawyers argued regarding how much notice these Venezuelan immigrants were entitled to before the Trump administration deported them. At the Denver hearing, Justice Department lawyer Michael Velchick said the government, the Trump administration, would give migrants notice that they were being targeted for removal under the law. Any migrant who then says they wish to challenge their removal would be given 24 hours to do so, Velchick said. Judge Sweeney said she would rule by Tuesday on whether to extend her order protecting two Venezuelan men in immigration custody in Colorado from being deported under the 1798 Alien Enemies Act. And friends, rule Judge Sweeney just did. And in substance, she told Trump's DOJ lawyers that, yeah, you can take your 24-hour notice recommendation and stick it in your briefcase. That's not exactly how she put it. Here's how she put it. Headline: Trump must give some Venezuelan migrants 21 days notice before deportations. Judge rules. A federal judge in Colorado directed President Donald Trump's administration on Tuesday to give Venezuelan migrants detained in that state notice 21 days in advance before any deportations under a law historically used only in wartime, and to inform them of their right to challenge their removal. In a written ruling maintaining a temporary block within Colorado on deportations under the 1798 Alien Enemies Act, Denver-based U.S. District Judge Charlotte Sweeney said the administration must tell the migrants in a language they understand that they have the right to consult a lawyer. Sweeney's decision marked the first time a judge has imposed detailed requirements on how the Trump administration can ensure due process rights under the 18th century law since the U.S. Supreme Court's April 7 order requiring migrants be given the opportunity to challenge their removals in court. And friends, just as we read in the prior reporting, during a hearing on Monday, a Justice Department lawyer said that any migrant wishing to challenge removal under the Alien Enemies Act would be given 24 hours to do so. And friends, what's Donald Trump's take on all of this? The deportations are part of the Republican president's hardline approach toward immigration since he returned to office in January. Trump was elected to a second term as president last November after a campaign in which he promised to step up deportations. In a social media post on Monday, Trump said the government cannot give everyone a trial before deporting them. We would need hundreds of thousands of trials for the hundreds of thousands of illegals we are sending out of the country, Trump wrote. Such a thing is not possible to do. You know, friends, isn't it nice when Trump says the quiet part, strike that, the unconstitutional part out loud? You know, one of his third-rate DOJ lawyers should really take him aside and explain to him the following. Mr. President, notice and opportunity to be heard in the context of a deportation matter is not a full-blown trial. Now, I can see why you might have a misunderstanding, because what you had was a full-blown trial, a criminal trial, in fact. And as you know better than anybody, that involves a grand jury exhaustively investigating your suspected crimes. And those members of the community, New York residents who were called to grand jury service, dozens of them, concluded that the evidence supported you being criminally indicted for 34 felonies. Then, of course, once the case moved into court, you spent months and months litigating motions to dismiss, desperately trying to get out from under the criminal prosecution you were facing. And of course, all your motions failed, right? The law was solid, the evidence was strong, and you proceeded to trial. Then you had to sit through a lengthy jury selection process. I'm sure that was tedious for you. When members of the community in which you committed these suspected crimes for which you've been indicted, they had to go through a rigorous process to make sure they could sit fairly and impartially and judge your guilt or innocence based solely on the evidence introduced during the course of your criminal trial. I knew that took some time and energy and effort and resources. Then, of course, we moved into the trial proper, and you had to sit there day after day through opening statements, through the government's case in chief, lots and lots of witnesses testifying about your crimes. They were examined, they were cross-examined by your attorneys fully, maybe not so effectively, but fully. And then at the conclusion of the government's case in chief, you got to present all of the evidence of your innocence. It was a very quick defense case. There wasn't much there. And then we moved on to first the government's rebuttal case and then closing arguments. And your attorneys got to make a full pitch to those members of the jury that you hadn't committed any crimes. You were plainly innocent and they should vote not guilty. And of course, once the jury finally got the case in their hands, they retired to deliberate. They ended up convicting you in a New York minute of 34 felony crimes. They barely had time for a lunch break. So I understand, Mr. President, that, in your mind, we can't possibly do that hundreds of thousands of times for all of these Venezuelan immigrants who have due process rights under the Constitution, but they're not going to go through that long, draining, strenuous, tedious, arduous process that you went through that resulted in you being convicted of 34 felony crimes because the jurors found beyond a reasonable doubt you committed those crimes. The hearings that these Venezuelan immigrants will get will be much shorter in duration. They won't be as involved. They won't last months and months. But the Constitution provides that they, like everyone else, are entitled to notice of what you, the executive branch of our federal government, is trying to do to them, deport them, notice, and an opportunity to be heard in court to contest their deportability. So, not to worry, Mr. President. The federal judiciary, the criminal justice system, actually is well equipped to handle all of these matters. So, don't worry yourself with the details. Let's just abide by the Constitution. Because, Mr. President, justice matters.